it is beneath my professional dignity and my professional ego to behave like an ambulance chaser. Because already there are certain negative stereotypes about our profession, and I don't want to reinforce them. Two, you have to realize the precarious position I typically find myself in, and most people may not understand this. If I take up more cases that relate to the community, I'll be accused of being jobless. Second thing is, if I do well, they'll say I feathered my nest at the expense of the community. If assume for a moment that in a particular matter the outcome is negative, this guy took it up because of his publicity and because of his publicity mongering, and he screwed it up completely. In either case, it really doesn't cover me in good light. I have been hyper selective about these things. One, I will never, ever be a full-time public interest litigator. It does injustice to my skills as a commercial litigator who is good at what he does. I will never do it. I am someone who is in love with his profession, and I know what I'm good at and what I'm not. So commercial litigation has given me the financial independence and thought independence to say what I say without being beholden to anybody. Okay? No party affiliations, no organizational affiliations under any circumstances. When you take up everything, after a point it becomes about you and not the cause. That needs to be avoided. And the idea has always been to widen the base of stakeholders when it comes to this battle. And that decision has paid off because multiple lawyers have turned up in so many high courts and even in the Supreme Court to take up our causes. In practice, in the nature of an arguing counsel, it crudely translates to the mold of a barrister in UK, which means my clients are lawyers themselves who engage me to argue on their behalf. I don't draft, I don't file. I did that for the first 7 years of practice. After that, I moved up the value chain. I'm very clear about what I will not do.